A client comes to know this at a very early stage from some very simple indicators. One of them is you're being able to imagine situations that the client has not imagined and allocating risks for them in a commercially viable manner for your client. Second, educating your client. So, through the entire process, you need to keep educating your client about where the possible risks could lie, what should the client's responsibility be from the perspective of his business, what would better protect his business interest. You can't be a lawyer who says that I will just ask from my client what the terms of the business are, what deal he wants, and then put it into words. No, you've got to play a much more proactive role than that. So you will need to educate your client. You will need to also recommend that what is a fair allocation of risk, how should it be best commercially viable for clients. And it's not a kind of catch-all recommendation that all risks are on the other side and this is what you got to deal with. No, it's got to be sort of workable, where it's you've got to arrive at positions or recommend positions to your client which would work for both the sides in a commercially viable manner so that the deal gets done. You can suggest possible room for the client to negotiate, like what is the negotiating room that the client has. Okay, you can work with them on that. Then giving them a simple document which they are able to read and actually understand. This is critical. Like this really increases the trust that your client has in you tremendously. Clients are used to having unusually long contracts filled with a lot of legalese, and trust me, a lot of it can be irrelevant. So putting in the clauses that are actually important and keeping the contract simple, consistent, reading it through for consistency. There should be no terms defined which are not used in the contract. There should be no extra clauses which are not needed. There should not be any missing clauses. And going through the document and keeping it tight and simple, that's very important. And this the client will come to know during the mandate itself. You don't have to wait for problems to show up later, right? And also during this stage, specifying to your client that what is the enforcement machinery that the client has available to him in case there's a breach. What actions can the client take? Keeping on educating the client on that while drafting the contract, this adds value. The second part of it is that the problems in a contract will show up later on. So, how good your enforcement machinery is in the contract, or how well you've imagined the different situations that can show up in light of the transaction, this will be actually proven true or false with passage of time. And at that time, you've got to be in communication and open to receiving inputs from the client, rather than being someone who disappears or who just does not take any responsibility or is not willing to help out the client. At that time, you've got to be sort of open and receptive about what's happening. Also, for the duration of the transaction, staying in touch on the different stages of the deal, so continuously keeping in touch and keeping the client updated of your progress in the matter, that's very important. A lot of times lawyers don't keep their clients updated from time to time, and clients have to keep requesting for updates or information. That should be avoided. And I want to clarify one thing, that if you are requesting or if you are over communicating with the client, that's usually not a problem. They appreciate that.